Welcome to today's edition of Robertshaw's Roundup, because I want to speak to you about three separate stories. Although knowing me, it'll be Robertshaw's Ramble and I'll go off and talk about dozens of things. But what are they? Firstly, there's the successful appeal of that lady who scared the cyclist who then went on to have a fatal injury. Also found out about the details of that public interest immunity application in the post office, and it's quite a doozy, to use the legal technical term. Seriously, check it, it's in Black's 7th edition. And also want to speak about something, the Solicitors Regulation Authority and some powers they are seeking, and also how they're getting on with dealing with these SLAPPs, these strategic litigation against public participation, and the fact that certain lawyers have perhaps been allowing themselves to be used to bring SLAPPs. So first of all, this lady. What's the background in case you don't know? Lady was walking on the pavement and somebody was cycling on the pavement. She did not approve of this and she remonstrated to the cyclist, who unfortunately then swerved and had a fatal accident. And she was prosecuted. She was prosecuted for manslaughter. She was convicted and she received a sentence of 3 years. And at the time, obviously a lot of people were sort of up in arms about this and saying it wasn't fair. And in all fairness, a lot of people were saying it was very fair. But it went to appeal. And the appeal ground was relatively straightforward. It was that she had been prosecuted for what we call unlawful act manslaughter. Now, manslaughter is an unfortunate word, really, because it describes lots of different things that result in the death of a person. It can be everything from sort of like negligent manslaughter to manslaughter through the grounds of diminished responsibility. But unlawful act manslaughter requires that somebody commits an unlawful act, and as a result of that, somebody suffers a fatal injury. And it has to be, you have to show causation, but for the unlawful act, the injury wouldn't have occurred. And what they said in this case was, well, what was the unlawful act? You went all through this and you said, here are the consequences, but the judge did not direct the jury that there had to be an unlawful act. Now, the issue here is, there are quite a lot of what we call standard directions in something called the Judicial Bench Book, because the idea is that people get consistent directions with regard to the law, so that it's not sort of postcode justice. But as it happens, there isn't a standard direction for unlawful act manslaughter, presumably because it can be very fact-specific. But one might have thought that one direction is, first of all, you have to establish there was an unlawful act. So what was the unlawful act here? Well, they were saying what caused the accident was remonstrating with the cyclist. But did that amount to an offence? Now, some people suggested it could it be common assault? Common assault, contrary to what you think, it doesn't involve actually touching anybody. It's just putting somebody in the immediate apprehension of the use of force. So shaking your fist in somebody's face can be assault, even if you don't actually do anything. But here, she just turned around and yelled at the guy. And they said, well, the test is really simple. Had nobody died, would she have been prosecuted? Would you have said, well, she's clearly committed an offence regardless, so prosecute her? If you'd just been walking down and, the cyclist had cycled on his merry way. And they said, well, no, clearly not. So, or certainly, the jury weren't given a chance to consider whether an unlawful act had been done, because they just weren't directed. So anyway, she has now been appealed successful and overturned. Theoretically, it's open. They could prosecute her again, but it just doesn't seem likely because the court more or less said, even though appeal courts don't like to find facts, they said it's difficult here to see what could possibly amount to an unlawful act. So that's that one. Public interest immunity in the post office. What's public interest immunity? I'll refer you back to my previous video where I went into lots of detail about that. But essentially, it's where somebody says to a judge, here is some evidence that we should disclose to the defence in a prosecution. However, for very good reasons, we should say it shouldn't be disclosed to them. Now, the test for disclosure is will this either undermine the prosecution or assist the defence? And the test is may, might. It's not that it will. So basically, this report, their defence being there's loads of holes in the Horizon system, and here is a draft report saying there are loads of holes in the Horizon system. So clearly that would have been disclosable. But they made a PII application, and they made it without notice. In the video, I explained that sometimes you can do it on notice, but this was one where the defence did not even know that the application had been made. So what were the grounds put forward? Well, there's a bit of controversy here because in the Post Office inquiry, people's memories seem to be, lots of I don't recall, but I do recall this thing that gets me off the hook. And there was a suggestion that because the report was about to be revealed in Parliament, that it shouldn't be disclosed until Parliament had said, this report exists. However, somebody involved in that decision, who I find quite credible, has said, actually, no, that was never put forward as a reason. But the reasons that we do know were also put forward, and I say, it seems likely only the ones put forward were, they said, the existence of this report, if people find about this report, it will undermine the credibility of a system that is in everyday use and does lots of financial transactions. It will undermine the credibility of the Post Office. It will cause speculation that there are problems with the Post Office, and particularly it will provoke press inquiries. Now, I have to say, I do not know, and I've asked around if anybody knows any examples of any PI application being put forward on grounds other than it's an operational security matter or it's a national security matter. We do not want to reveal the name of our confidential informant. We do not want to reveal where we put the surveillance cameras in this case. We do not want to reveal, the workings of our top secret, radar network. But, so it's literally things like that. So potential reputational harm. It just seems such a strange, thing to make a PII application on. However, the judge granted it. However, it is fair to say that the judge said, we'll revisit this decision in 8 weeks' time. So it might well be, I've discussed this when talking about injunctions, sometimes when a judge isn't quite sure what to do, they will just preserve the status quo on the grounds that, well, at this stage, is withholding it harming the defence? Not necessarily, because we'll visit later on whether, it should be disclosed to them. And they would be getting it well before the trial because they did actually adjourn at the same time, so the trial got bumped back. It's a strange one though that the judge would have allowed that, and like I said, I can only presume it's because the judge just sort of got didn't understand maybe what the application was, because this is something that's come out that somebody was sent down there and everybody's insisting that they didn't know what the application was for. I'd be interested to see what counsel says. People go, oh, I just went there, I didn't know what was going on, I just made a note, I don't know what PII applications are, despite being involved in criminal litigation for 20 years. It's all very suspect, isn't it? But yeah, there you go. It was a Judge Chambers. Ironically, it was heard in Chambers, ex parte, without notice. But it was in Birmingham Crown Court. I won't name a particular case or anything, because this is sort of, the information is out there. I don't think it's a secret, but naming the victims, they've been through enough. Especially as I've noticed, you do get people sort of going, oh, they're still all guilty. That's what really just surprised me. But yeah, so that's what the PI application was. And the interesting thing is, one counsel involved in it has now said it clearly shouldn't have been made. And he said, at least though 2 weeks later it was put right and the Horizon report was disclosed. Okay, and finally, to come on, it should be like a funny animal story, shouldn't it? The last story. So, let's just pretend sort of Cappy Barrister did something amusing, like stole a car, or Lord Loverduck. Say hello, Lord Loverduck. Lord Loverduck did something, that had got him on That's Life. But anyway, it is the Solicitors Regulation Authority have said they wish to have powers to spot check solicitors' firms. That is, that just randomly go in and start sniffing around, because they can only go in at the moment if there is a complaint, and also the complaint has to be very specific, Because they've asked for another power, which is somebody can just do something on, I think there's something not quite right with this firm. Because at the moment, if you say that, say, well, we can't investigate, you've got to say, they have transferred this money incorrectly, or they have not registered this document, or they are not filing things in time. You have to be very, very specific. So they certainly want some broader powers to just sort of, randomly inspect. And it'll be interesting to see if they actually get those. But also, I've just lost one of my lights and gone spooky. I do actually have a spare for that, but I'm not going to do it now. I'm not going to edit this. They've also started doing this SLAPPs thing, because they sent guidance to solicitors saying, "Oi, stop threatening people, with defamation proceedings and bullying them. And also don't claim things like, you are not allowed to refer to this, it'll be defamatory if you do. Stop hiding things behind without prejudice. When it's not without prejudice." And they've just said, don't lend yourself to SLAPPs. Now, they have had 72 complaints of people saying, I am subject to a SLAPP. And they have referred 2 of those complaints so far. They've said, this has been found, there's something here that needs to go to the disciplinary tribunal and be investigated. They've dismissed about 30 or 40 of them and said, no, that's probably within the remit of a legitimate letter before action, and there's still about 30 to consider. But it'll be interesting to see, because this anti-SLAPP litigation, obviously, it's interesting to me because I do defamation, but also, I do all the animal rights stuff, and, people use litigation a lot, not just defamation, against animal rights organisations. So I'm keeping very much an eye on what's happening there. So there you go. So that was a roundup. I'm just doing this new format. To be perfectly frank, I was going to do 3 separate videos, but I've just been so busy today. I'm just sitting down and I thought I'm just going to do them all in one take, just make it easier to edit. But there you go. If you found any of that vaguely useful, vaguely interesting, vaguely accurate, please consider clicking, liking, sharing, subscribing, and all that Facebook sort of stuff. And let us know, actually, if you'd like me doing the longer things or the shorter things. I do welcome your feedback and also your suggestions for things to ramble on about.